Hello, we are live. We are live. I am Vince. I am Vince White. I am an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We're live for at least 1 hour today. Well, I guess before I read the first question, really quick, how many of you have seen the new app video as like a conversation prompt? Because we got the live chat going. Did you? Because we launched that video today. It was kind of iffy doing a Saturday launch, but it's just how it worked out. Because of me, unfortunately. And yeah, I'm very curious for feedback on the app launch video. Not launching the app. I shouldn't say launching, but I guess the first of the developer check-ins where we do collaborations with a member of the dev team to see how the app is coming along. All right, so that's my prompt for conversation with the chat. Got myself a cough drop here. Okay, first question, YouTube user Anonymous says, "Hi Vince, first time caller, long time listener, LOL. The app dev made the same joke yesterday. I laughed then, I'm laughing now. I saw a post that Anonymous goes on. I saw a post that said this person's employer hacked their phone. Whether that's true or not, it's a good idea to get a birder phone when suing. So, oh, your question goes on. When suing your employer, especially if you're still employed there. Okay. So, if you have a phone that does not have an app from your employer on it, you're good. Unless you're in like a tens of millions price bracket. Like, listen, if the amount in question is tremendously large, I'll tell you right now, it appears to be very easy to hack a phone in 2025. One of the main issues we have when we hire private eyes is to make sure they're not like hacking phones. And the price point on that is like $5,000, $10,000. And we don't want them hacking phones because like laws, right? Like we have ethical duties to uphold the law. And if we're hiring a vendor that's breaking laws, that's a problem for us, right? So I guess my takeaway here is you really got to be a significant problem for the employer to go slap down $5,000, $10,000 on a PI that's going to like hack your phone. They don't need to touch your phone to do that anymore. Like from my understanding, like it is very easy to gain access via like, I guess I would call it like Trojan operations, but it's not even really like, I think there's some versions of security on phones that like even opening a text message, not downloading something, but opening a text message can be sufficient in certain circumstances. So, do be aware of that. But that being said, the real concern in our industry is if you have your employer's software on your phone, or if you're using a phone provided by your employer, that's a deal breaker. Like you can't do that. You got to get your own phone to talk to your attorney, and you got to make sure that none of the software from the employer is on that phone, because it is a real risk factor. And listen, certainly on our excuse me, just ate lunch. On our higher end cases, our higher valuation cases, where valuations, you're talking 7, maybe even occasionally 8 figures. Yeah, listen, at that point, security is different. And we've seen things like Signal not seeming secure, like the employer seems to know certain things that are happening that they shouldn't know, stuff like that. That happens. So, a little security doesn't hurt. Okay, next question. Also, YouTube user Anonymous got like 4 questions in off the bat. That's a smart way to do it. Hi, Vince. If the employer has taken 10 months to medically accommodate me, is that unreasonable? Yes. If you sought a reasonable accommodation and initiated the reasonable accommodation dialogue and supplied some, paperwork from your doctor, and you were responsive for follow-up, then yes, that is too long. They don't agree with the accommodations me and my doctors requested. Yes, plural. So they're trying to find another accommodation for me. But in the meantime, they're giving me the accommodations my doctors and I requested. Will I wait for them to find one they want to give me? It doesn't make any sense. Well, I'll say this. There's two ways to look at that, right? If they're granting you the accommodations you asked for in the meantime, there is an argument there that if they can grant them, they must be reasonable. Counterpoint, they're kind of doing the right thing. So they're granting you the accommodation, which they find unreasonable, while they try to work something better out that still helps you, but is less onerous on them. I'm not sure that my view is that employer is such a bad employer. If you're saying that's what they've been doing for 10 months, like they've been engaging the reasonable accommodation dialogue with you, and they've been granting you an interim accommodation where they engage in that dialogue and try to find something that works better, that's not too long. That's them engaging in very good faith in the reasonable accommodation dialogue. And I don't really know that that's necessarily a claim, but, check with local counsel. Okay. YouTube user John Craig says, had my mediation. We had reached an impasse, but the agency came back with an effort to reassignment, leave restoration, and $15,000 toward attorney fees. Any idea why the agency may have gone and changed their stance? They want to get the case settled, so they tried to make you a better offer. Oh, I see. You go on. Basically, they went from a non-monetary offer to offering something. Still not a great offer, but it is something given the current climate, anti-DEI, etc. Yeah, I mean, listen, it sounds like they are trying to figure out what you want, and they want to get you out, but they want to get you out on the cheap. Vanessa K says, hi, Vince. Please go back to having lives during weekdays. I am going to miss out today, unfortunately. Vanessa, I will try to do lives on weekdays. Didn't have time during the week this week, so I'm giving up my noon slot on my Saturday to get y'all a live stream. But I'll be frank, I'm gonna do live streams whenever they fit in my life, and you can always watch them afterwards, right? If you can't catch them live, that's okay. I respect it. There is no duty to watch my live streams. If you do, I ask you give me that free like, because that free like is how YouTube lets other people see us in the algorithm. But if you don't need our answers, you don't need to watch. It's okay. YouTube user Jeremiah McKinnon says, Vince! Exclamation point, exclamation point, exclamation point. Good afternoon. Good afternoon, Jeremiah. By his grace says, why would the defendant in an employment lawsuit case provide their liability of insurance in their initial disclosure that was filed in the state court in Florida? I thank you so much. Also, they are asking for my case to be dismissed with prejudice. Does this mean there could or couldn't be a settlement? Okay, so sounds like the initial disclosures might have required information about insurance, and that's why they're turning it over. Or they're just looking to tell you what the insurance limitations are. Like, what are the limits on the policy? Good, now you know. Their perspective might be, that's all you're going to get. So, like, now you know, right? Could be either one. Not really meaningful. Listen, them filing to get your case dismissed with prejudice doesn't mean that settlement is or is not on the table. But, they might be trying to apply pressure while they talk settlement with you, so you take a smaller settlement, or they might just think they can get it dismissed and they might not want to pay you anything, right? Like if your complaint was not properly drafted, or if there's like some novel question of law in your complaint they think they might be able to win on, they might want to see what happens before they cut you a deal. Titan Mastiff says, Vince, do you know anything about MSPB cases? I received acknowledgement order, but the agency never appointed counsel. The order stated they had 20 days. I haven't been able to request discovery. I mean, yes, we know a lot for federal employees, but that being said, I'm not going to be able to answer your situation. I haven't reviewed anything in your case, so I don't really know what's going on, right? YouTube user Bubblegum says, hi, Vince. I'm supposed to have a mediation with my former employer, but they keep delaying it with excuses. Since mediation is required, is there anything I can do to move it forward? Well, you can refuse to You can refuse to grant any further adjournments or extensions if you want. The other thing you can do is if it gets really long, I guess you can investigate, if there's a motion that you can make to compel the mandatory mediation. That seems aggressive to me. I don't know if that's really necessary. I don't know if it's a good use of your time, but that's available. YouTube user AJ Sofly69 says, like the live, everybody, it's free. It is free. And you know what? We have 28 concurrent viewers and yet only 17 likes. And it is free to like the stream. So, it does help us. Ruben Rubino says, good afternoon, Mr. White. How can I contact you directly? You absolutely cannot. You never contact me directly unless you're my client. That's not going to happen. No, let me be serious. You can talk to our intake people without question. Like we have a website, www.nycjobattorney.com, or, a variety of other sites throughout the rest of the United States. But I do not offer free ask and answer. You cannot just contact me with questions. I do not have the bandwidth for that. Our firm is dealing with an incredibly high call volume these days. And I'm sorry, like there was a time in my career where I could just help everybody out. That time is long past, and I'm sorry. I get the idea. You're just like, you might just be like, hey, I just want to pitch a case. Absolutely. You can talk to our intake people. We're thrilled to do that. We have a call center. We have chat operators. We have people who call you back and, dig into the claim before you get attorney time. And if you have good interactions with those people, with those various layers of intake, then you could very well end up on a call with one of our attorneys or even with me, right? Like I do take some of those calls myself, especially the ones I really like. I have a couple of passion projects. There's things I particularly care about. I'm really passionate about workplace sexual assaults and workplace sexual harassment cases, because it's really hard, I think, to have a society where huge portions of the population are just constantly coming under pressure to give like sexual gratification or sexual affirmation to just keep their job or to get ahead in their career. Like that's horrific to me. I also I really care about race cases a lot. I pay a lot of attention and care a lot about some of the racist tropes of like the angry black woman. Like she's advocating for herself. Like she must be the angry black woman. I hate when that happens. I really feel passionately and strongly about those cases. Painting African-American men as aggressive. I don't know. He seems pretty calm to me. He's calmly debating your infraction of the labor code here. And they're like, no, he's an aggressive black man. Okay, you're racist, right? Like, so like I care about those cases. I like have an interest in those cases beyond just like, yes, I want to help and like we'd like to make money helping, right? So I have certain passion projects that I care about. Whoa, chat jumped ahead. Sorry about that. Allergy season. Okay, what do we have? Questions. Catching up with chat wherever it was. Jeremiah McKinnon says, Vince, don't read my message. Prematurely sent. I think I might have already done it. I'm sorry. YouTube user Jai Sion says, how likely can my attorney get a settlement after the right to sue letter from the EEOC? Happens all the time. They told me 2-3 weeks to see if they can. Yeah, that's reasonable. It's been 1.5 weeks. Should I call, check status, or look for a federal lawyer? Yeah, I don't think it hurts to call your attorney and check status. I mean, listen, they work for you, right? Excuse me. YouTube user NYC Damages says, hello, Vince. Great to see you. Hope the farm is productive too. It is. Thank you for checking in. Hit the like, everyone. It's free. It is free. Thank you for pointing that out, NYC Damages. You're so on top of things. NYC Damages goes on. I need to add a defendant and amend the complaint. Do you have to do that before you serve the complaint with summons, or can you also amend after serving? Will a judge allow it after you have served already? Okay, so really quick, and you have to check your rules, whatever venue, jurisdiction you're in. You have to check the local rules. Commonly, what I see in federal court is as follows. You file a case in federal court. You have 120 days to amend as of right. After that, you can amend by leave granted by the judge. Whether or not you serve is not necessarily relevant to whether or not you can amend generally. And again, check your rules, check your jurisdiction, talk to local counsel. This is a general discussion, what I generally see, right? Now, whether or not you serve doesn't necessarily matter whether or not you can amend, but if you're not doing waivers, service by mail through, waivers of service, could get, could be a little less efficient. YouTube user Bubblegum says the judge requires mediation before court. Yes, mandatory mediation, very common. I don't mind going to court, but do they think stalling will make my claim go away? I don't know. They might actually think you'll live up. They keep missing deadlines. Can they be held accountable for that? The court will eventually hold them accountable for missing deadlines. And there's things you can do, once it gets very egregious, to raise that to the court and push for, some kind of sanctions or punishment to, hold the other side accountable. But it is often a very high standard with courts to have them hold the defendant accountable like that. The Incredible Boom Boom says, 1 afternoon, trying to think of creative ways to vacate arbitration agreement. Good luck to you. I have audit logs of supervisor spoilating evidence and logging into a senior HR official's accounts the day. 2, the company received the EEOC charge. My attorney let them know about the improper HR data access. Nothing has happened to him. Thinking of arguing the employer materially breached my contract. Yeah, I mean, I guess I would recommend talking to an attorney in your jurisdiction about the standard in your jurisdiction for overturning an arbitrator. Because I don't know that, it sounds like you're saying, I have new evidence, so I should overturn the arbitration. And just putting myself in my New York brain, I don't think that's a super strong argument for overturning an arbitration, if I'm being frank with you. But, generally speaking, to overturn an arbitration in New York, you have to prove that the arbitrator was arbitrary and capricious. Essentially, there was no rhyme or reason, no logic whatsoever for the decision the arbitrator made in order to get that arbitrator overturned. If you stop and think about that standard, you're not saying the arbitrator got it wrong. You're saying the arbitrator engaged in gibberish. And that's a really hard thing to prove on a well-reasoned decision. And presenting new evidence that you didn't present at the arbitration is on you. That's not the arbitrator's fault. That doesn't necessarily serve to overturn the arbitrator's decision, that based on the fact that you didn't present that at the arbitration. But that being said, listen, check the local rules, check the local standard, check with local counsel. I'm speaking in terms of New York. And also I'm speaking in generalities. I'm saying it's not the best argument. I'm not saying it's not an argument, right? Okay. Daughter of the King says, what happens if your company does not respond and does not want to settle? Then you got to push your case forward and try to win your case. Rolando Arribas says, my employer violated my labor agreement with my union by terminating me without cause, by exceeding the time frame required to issue a disciplinary action. Can I sue? Maybe. If you're a union member under a collective bargaining agreement, I think you probably have a step grievance process that will lead to arbitration. That might be the path forward for you, but you might also have private, causes of action that you could bring. Speak with local counsel. Bubblegum says, thank you, Vince. Let me hit this like butter now. I'm sure that was a typo and you meant like button, but I like the idea of like butter. I might make butter today. A little time in my hands today. I might make some butter from scratch. That might be fun. The Incredible Boom Boom says, 3, by allowing criminally illegal actions. Okay, you're still talking about. I'm not going to read that because you're still talking about overturning the arbitration, and we already kind of covered that. Titan Mastiff said, "Sorry, I ran out of characters, but my question regarding MSP situation is, what do you do if the agency doesn't respond to the acknowledgement order? I mean, eventually you're going to contact the court, with like a motion to compel or something along those lines. I don't know. I'm not giving you that specific legal advice. Look into what's appropriate under the circumstances, but yeah, you're going to contact the court." The agency, the person hearing the case, right? Silence is Golden says, "Have you ever busted an employer altering emails to say it was from your client? Altering email addresses and timestamps? I appreciate your answer." Yes. The answer is yes. Although it's very important to know who's controlling the email server, right? So like there's some employers who do the stupid thing of like just editing docs and not have, like not realizing that like, okay, you've asserted that like this email was sent by my client on this date at this time to these people. Why isn't a record of that email being sent present in the email server, right? Like our forensic our forensic IT vendor says that there's no such, didn't happen. There's no record of that email. Like you have that email in hard copy. I see it here, but your server doesn't. So what's happening, right? And that happens a lot of times when you have professionally controlled servers by third-party vendors, as many employers do. There are, of course, employers large enough to have their own internal servers, and there's some possibility of tinkering at that point, which is why you have forensic IT vendors in it, and you have attorneys who can afford them and who know how to use them, right? Health is wealth. YouTube. Whoa, Chad jumped on me. YouTube user, health is wealth. Health is wealth. I agree. Hi, I submitted a complaint with the New York State Division of Human Rights. I have an attorney, but after the position statement, there have been nothing else in the past 17 months. The case involves discrimination with the employer, withholding retirement benefits. Is this amount of time normal? Can this be a positive or negative for finding a probable cause? Let me get a little bit of water here. Yep. I don't think 17 months is wild. I think your attorney could probably push things along. Our state division cases certainly run faster than that. But like I definitely know firms with 2 and 3 year state division cases active. It's not insane. I don't think it means anything in terms of settlement one way or the other. All right. What's next? My name is says, "I keep getting told to file with DWD and the EEOC prior to retaining a lawyer. Their words, but based on my situation, I was hoping they could help with the entire process. Is there a reason for that?" So I actually have videos on that and why I think that attorneys make a huge mistake by wanting you to file the EEOC on your own. Firms like mine, and there's a fair number, about a third of the industry agrees with me. They want to handle the case from the outset. Ideally, like we'll take a case that came back later if it's a good case, but my ideal, if I'm choosing, I get a case from day one, right? The earlier my firm is involved, the more we can reduce risk, the more we can add value. So, their idea is like, let's see how the EOC goes, get some free discovery. Then I'll know a lot more if I want to take this case or not. There's something to that, but like you're leaving so much up to chance because my name is it's not your job to run these cases. You don't know how to get the best evidence. You don't know what the best arguments are. It's just not your job. I'm not saying you should know, right? Like I'm sure I can't do your job, right? So I think it's very foolish for firms to be like, no, just go handle the EOC yourself, and we'll take it from there. What's going on with my hair here? My goodness. Excuse me. YouTube user Pamaroon says, just saying hi, cheeks. I hope your weekend is going good. Most importantly, your health as well. Thank you so much, Pamaroon. Recently, we sued a very high-profile individual and got a lot of press on it. And I guess that individual's fan base doesn't like some things I said about that individual in Rolling Stone. So they've been like finding me and spamming me to say mean things to me. Because of course we should be mad that I'm pursuing the guy who did horrible sexual harassment things and sexual assault things, right? Like I'm the problem in that scenario, obviously. But this guy, like I just woke up one day and I had like 13 or 14 emails from this guy who was like calling me jowls. And I was like, jowls? And I like looked at the mirror and I'm like, huh? I mean, not yet. Like that. I was like, that's a weird. I don't know if we're there yet. Give it 30 years. Maybe we're gonna have some jowls. Like I could see the cheeks drooping. I could see it, but I was just like, huh. I mean, I get you. You know, you're throwing whatever you can against the wall to try to get me upset. But it was one of those like, huh? I don't know. Just amused me. My name is So says, I have everything laid out, including a timeline, witnesses, and tons of evidence. My name is So. I would check out our playlist of videos on how to get, how to go about pitching employment attorneys. That can be helpful to a lot of people. What do we have here? Ooh, chat jumped. Okay. YouTube user SC says, is disability discrimination claim still the EEOC's number one priority? I don't know. I mean, they're really into anti-American citizen discrimination right now, they claim. So, and like reverse discrimination stuff under the new director, that was the statement. So I can't tell you what their number one priority is right now. YouTube user Sonia Underwood. Sonia, hello. Hi, Vince. After working pro se on your case, what to do if your attorney hasn't answered your question about your case in 2 weeks? Am I being an asshole? No, not at all. I don't think you're being an asshole. Is your attorney not being responsive? That's a big concern. So like our firm should have a 24-hour response time at a minimum, generally a same day response during the work week. And then for non-urgent things that come in over the weekend, Monday. So yeah, I think it's inappropriate if they're keeping you waiting for 2 weeks, unless they're telling you like, hey, we don't have the answer yet, but we're going to get you the answer. Like if they're ignoring your communications, that's a problem. They're telling you, hey, you're asking a question we don't have the answer to yet, but we'll get you the answer in 2 weeks. Well, that's a different thing, right? YouTube user, my name is So. I'm still employed, but I believe constructive discharge is relevant as well as unpaid. You gotta try to get these questions like together because we're just like randomly reading paragraphs from you that are kind of they're non sequiturs because like they don't make sense. We've read questions in between. I think like the long stories don't really work for the live chat because none of this makes sense now. I don't really know what we're talking about. The Incredible Boom Boom says, clarification, arbitration hasn't happened yet. I anticipate they will file a motion to compel arbitration. We get to that point. Thanks. Okay, so you're trying to make arguments to not be forced to go to arbitration. I mean, it depends a little bit on the jurisdiction, but generally in most of the country, I would say to you, good luck. Yeah. Most of the country, that's not necessarily a likely. I mean, depends where you are, depends what the clause that compels arbitration says, certainly, but may or may not be viable to fight that. YouTube user Raymer Remar says, thank you for your time today in providing us with valuable insights in the law. I hope they're valuable. Certainly. Ooh, chat jumped ahead on me. Rolando Rivas says, thank you for answering my question. Have an excellent day. Continued success. And to you as well, Rolando. Sonia Underwood, Attorney Vince, make butter. I will buy your butter. I mean, we make a fair amount of butter. Right now, I'm kind of selling eggs primarily. We're not, the meat's all kind of coming in and starting next month. We're going to do 100 Freedom Ranger breed roasting chickens and then 30 turkeys this year. We've got our pig program. So we're going to have 4 pigs ready for harvest this year. And then we have our breeding trio creating, more pigs to harvest. So we got a lot going, but I don't know if I can sell the butter. I wonder if I could. YouTube user Eric Rose says, hi, softball tournament tomorrow. Softball tournament tomorrow. Eric Rose, I am not attending a softball tournament tomorrow. I appreciate the invite. YouTube user Prince 02 Dunn says, I believe my school district let me go for racial discrimination, retaliation, and disability discrimination. How difficult is it going after a school district? It's just extra work. They're not playing with their money, so it takes more time. You often have to litigate longer because they're paying with taxpayer money, not their money. So they care less about what happens to the money. They might be less rational or less concerned or just less intelligent with settlement strategy. Okay, YouTube user CNote1906 says, hi, Vince. Thanks for everything. My case in California federal court is moved to a new judge. It's been 2 months since the new judge was assigned. What on earth takes so long to set a new schedule? Judge is going to judge. Listen, federal judges are very confident in their own power, and they are going to do things that suit their schedule, not yours. In their view, it is their world, and we are just living in it. And, they're not necessarily wrong, depending on what you want from the judge, right? YouTube user The Blessed Hope says, in a retaliation case, I believe my company used a LYTX, a LightX drive camera to state that I broke a safety rule. I asked to see the footage from that day and time. My company refused. Are they legally required to show it to me? If you get discovery rights, like if you bring a case and it goes to discovery, they would potentially have to turn that over if it still exists. Yeah. In terms of them firing you, no, they don't have to show you anything at the moment they fire you. In most jurisdictions, check the rule of your jurisdiction wherever you might be. Rules vary wildly from jurisdiction to jurisdiction. Check with local counsel. Jeremiah McKinnon says, man, y'all see Vince stretch? He jacked. LOL. Did I stretch? I didn't. Well, thank you for noticing. OK Station said, settled my case, Vince. Congratulations, OK Station. It was for a lot less than I would have wanted, but it's better than nothing, and I get to leave that cesspool that is HHS. Thank you for all your help. That makes me really happy. That makes me super happy for you, OK Station. My name is So says, sorry for the gap. Chat moves quick sometimes, but thanks for the input. I'll keep reaching out to firms. You got it. My name is So. I'm sorry that I couldn't track because it just if there's 7 questions between your paragraphs, it's super hard, to track and respond intelligently. Prince 02 Dunn said, how can you overcome constructive discharge? What do you mean? If you're a plaintiff, you're the one making the constructive discharge argument. You wanted to resign. You felt remaining was untenable, so you resigned. So you're making the constructive discharge argument, and the employer's saying it wasn't constructive. So how you're not? I would presume you're a plaintiff, and you're not trying to overcome that argument. You're trying to make that argument. Health is wealth. YouTube. Oh, we're almost caught up here. We're doing great. Health is Wealth says, does having an attorney make a significant difference with the New York State Division of Human Rights complaint? Yes. Yeah. I mean, listen, there's investigators with the New York State Division of Human Rights who don't even read the charges. I can identify multiple New York State Division of Human Rights attorneys by name who my firm has a standing policy. We maintain a list that you must, when you're on the phone with them, read the charge to them like force them to stay on the phone and read the charge to them, because that is the only time they will digest the contents of the charge. That and listen, there are good people at the New York State Division of Human Rights. There are. I can think of a few. One of them really likes Superman, a whole bunch. But a lot of the people at the State Division of Human Rights do not give a fuck about you, about discrimination, about sexual harassment, or people being hurt by employers. They just care about not doing work. And, you know, it's really gross. So, yeah, having an attorney at the State Division of Human Rights level can be incredibly important. Your question goes on. Why would an employer submit what is deemed not a strong position statement to the complaint? Might be the best they can manage. Might be they had crappy attorneys. Might be they failed to convey information to the attorneys properly. Might be they're not taking you seriously. I don't know. I always, don't count out incompetence or circumstance. Okay. Zay Madden, YouTube user Zay Madden says, "Hey Vince, what is your experience with suing trucking companies?" Depends what I'm suing them for. My company is taking the P. Diddy route, meaning that they don't think I will file in federal court. So if you're suing them for workplace discrimination, workplace sexual harassment, first thing I would say is, if it's a trucking company, pay attention to whether or not you're an independent contractor, and if you're properly classified as an independent contractor. If you are an independent contractor and you are possibly properly classified as an independent contractor, check the rules of your jurisdiction vis-a-vis independent contractors dealing with workplace discrimination or workplace sexual harassment, which is, I assume, what you're suing for because you're asking on this channel. If you're suing for like FLSA wage stuff, that is very complex for truckers. And I would urge you to get a free consultation with an attorney who handles that specific claim routinely. And that, again, would be FLSA, unpaid overtime, unpaid wages for truckers. That is very complex, unexpectedly so. Okay. The Blessed Hope says, "Thank you." You're welcome, The Blessed Hope. NYC Damages says, "Thanks. Just to confirm, in New York City, if I file the complaint initially on day 1, serve day 60, I have 60. No. The key part of my answer to you was you go check the local rules. Do not rely on my off the top of my head general notes about what might be going on, right? Like, that's not, presumably you have a case that could be worth lots of money, right? Me, guy on the internet, generally giving you advice, being like, hey, in federal court in New York, generally it's going to be like 120 days as a right. And then after that, you got to ask for leave. That is a generality. That is a general recollection. I do not have the rule in front of me. You, whatever court you are in, whatever specific court you are in, identifies it state court. Great. Go check the rules for your specific court as to amending. Okay. And I'm sorry, it's just not, you cannot take procedural directives from a YouTube channel. Like, we can talk in generalities and be like, hey, watch out for this. Think about of right, not of right, serving, like that. We can talk about the generalities, but like, you must go check the rules. And the first part of that question was, you check the rules. And I don't mean to be like forceful with you, NYC Damages. We have a lovely back and forth. This concerns me. Okay. Okay, Station says, "Keep doing great work for the people, Vince. Wouldn't have gotten my settlement if it wasn't for this channel." Wow. Thank you so much for saying that. Can I like your post? I don't think it lets me like posts. Sad. All right. Well, I love your post. Thank you so much. It's very kind of you to say that. NYC Damages goes on, "What if I'm already on day 150? Can I amend? And if I need permission, how do I ask, write, amend?" Okay. So NYC Damages, if you've gone past, let's assume you've checked the rules in your specific court and you've ascertained what the rules are in your specific court where you are as in terms of amending. And so you're saying, hypothetically, the rule says you have 120 days to amend as of right. Then after that, you got to ask for leave. Those rules probably set out the path to ask for leave. Generally, asking for leave to amend can probably be achieved in a letter to the court. Check the local rules as to how the court wants to receive that letter. Make sure it is, also addressed to the other party, so you're not having communications directly with the judge, cutting out the other party. Okay. YouTube user Laura Lee says, how important are character statements in a he said, she said sexual harassment case? Not very. Usually. So like character statements, I think the key thing to remember are generalities. They can't establish what happened in the moment because that person doesn't have any knowledge of what happened in the moment. So they're of questionable relevance. And then the reality is that like a jury doesn't care at all, right? Like, oh, your sister came in and said you're swell. Yeah, of course she did. She's your sister. Like whatever, right? Your best friend came in, your work wife, your work husband, your best buddy on the job says you're amazing. Cool. Who cares? Like that's just not valuable evidence, not really to most people. And I'll tell you right now, I think the average jury member has almost zero interest in that. And they're just like, what do I think of this person? What do I think of the two people engaged in he said, she said? As an arbitrator, like when I'm deciding a case, I don't heavily weight character statements. Like, oh, he was swell in the Boy Scouts, did a lot of volunteering. Okay, but I mean, listen, there's serial killers who do a lot of volunteering. You know what I mean? Like, okay, like, what are we talking about here? Like, this doesn't really, Sonia Underwood says, hit the like button, guys. Thank you, Sonia. Okay, Station says, mischievous face, I believe. Karen Gladoo says, hi, Vince. What can I do if my union failed to show up in my hearing? I have since been fired. Well, I would talk to your union and see how they're going to make it right. But also, you could potentially file with the National Labor Relations Board or speak with local counsel about a failure to represent claim if such a claim has a viability in your jurisdiction. Okay. YouTube user Secret Dad. Are you a secret dad? Like, they don't know you're their dad? Or, like, how does it work? Or, like, you're their dad, but, like, you're a secret. You don't leave the house? Like, how does it work? What is a secret dad? All right. Hello, Mr. White. I suffered disparate discrimination. Would defamation per se be a separate charge than the original? So, listen, I don't know your situation. You're asking me is, do you have a claim for defamation per se? There is no reason to believe in a disparate treatment discrimination claim that defamation per se is necessarily in play, but it's up to the facts. Like, if someone engaged in the elements of defamation per se in your jurisdiction, then that would be a separate claim. A separate claim for you. So I have no idea if you have such a claim or not, but I'll say this. It is super, super common for plaintiffs to go around thinking they have defamation claims in this field. And attorneys, like 30 attorneys, will be like, yeah, I'll take the discrimination claim, the disparate treatment claim, but I don't want that defamation claim that you think you have. I don't think it's valuable. And they'll freak out and they won't hire that attorney. And that's okay. That's their prerogative. But like at some point, when you're talking to those attorneys and like 30 attorneys, like, yeah, discrimination, disparate treatment claim looks good. The defamation's trash. I don't want it. At some point, be like, oh, those 30 people are the people who do this for a living. And like, maybe I should listen to them. Yeah. YouTube user Kelsey, no relation, I suspect, to Travis Kelsey, who I do not care for, says, I just think he's a bad guy. I think he's very unlikable and like kind of like a piece of shit human. But I digress. No relation, Kelsey. Is it common for court reporters to alter deposition transcripts to help defense counsel? No. It is very uncommon. If you have any fear that could be happening, just shell out for the videographer option on the deposition, so you have a video that you can compare to. Excuse me. YouTube user Secret Dad says, also, thank you for the answer about me being denied access to HR. Seems like a long waiting game with the EEOC. It can be. It certainly can be. I mean, we can get in and out of the EEOC in a month if we want, but that being said, it can be. YouTube user NYC Damages, I get what you're saying. Where do pro se ask for the exact time to allow amending the complaint in federal court in NYC? The Pro Se Support Office is a great place to stop. Also, whatever court you're in, whatever judge you're in has local rules. You should be reading those and familiarizing yourself with those local rules. Native 2458 says, can I sue an employer for trying to stalk harass me into accepting a job offer? I mean, it depends on your jurisdiction. It could be like a civil harassment claim. Certainly there could be I can imagine there being claims there. So like check with local counsel. It's entirely possible. YouTube user Be Me. That's a cute name. You just want to be me. B as in capital B. What can happen if a company claims to have done investigations on discrimination and retaliation complaints, but they have no records or documents of the investigation? Well, listen, pick or it didn't happen in the parlance of the internet, right? Like, why would there be an investigation and no report? I would contend that that investigation didn't happen. And, you know, in that they might, you know, be wayward in their duties, their affirmative duty to investigate. Now, that being said, could be that whoever did the investigation just didn't know what they were doing, and they actually did the investigation. They didn't create some kind of written documentation of that. That's theoretically possible. And listen, if there's 10 people involved in the investigation and all 10 people are questioned by the same person, and you know, those 11 people, the investigator and those 10 witnesses can all testify to the investigation happening, well, then I guess it probably happened. But if, you know, if that's not the case, if there's nobody but the investigator saying it happened and there's no documentation of it happening, well, you know, I have concerns, right? What really happened? All right, short break. We've been going 48 minutes. I just got a notification that someone's using my Netflix account. It's a little bit sus. Not gonna lie to you. I was like, who's using my Netflix? I really want to get outside and work on the farm today. I'm gonna do that as soon as if the rain holds, I'm gonna do that as soon as this is over. All right, what do we got? Ooh, chat jumped. So we have 37 likes, 33 concurrent viewers. Thank you so much, everybody. YouTube user Jers, that's a cool name, says, with constructive discharge on top of unpaid wages, benefits, retaliation, and breach of contract, is it better to leave prior to taking any legal action or having a lawyer help navigate the exit? So I actually have videos on this. If you can stand it, and I'll give you the 20-second version, and then like I recommend you go find the video. I think it's like entitled like setting a trap for your employer or something like that. If you can stand to stay while your case pens, it is a tremendous leverage point for you and for your attorneys negotiating because of the risk of retaliation, liability that your employer is exposed to. It can be a real power position for you to be in. A lot of attorneys don't like that. A lot of plaintiffs don't like that because like the quality of life in that position is not great. It's very stressful. But if you can do it, if your disposition is such that that's okay for you, then it's great. We got a high pollen count today. All right. YouTube user NYC Damages says, got it. No ex parte communication. Thanks, Vince. Nice to get what you're saying after all these years. Yeah, you're doing great. YouTube user Laura Lee says, I meant more from new coworkers Laura, if you had a prior question, I don't think I saw it. So if you're clarifying something, I don't think I saw it, but let's read your question. And I only think that because this is the first time I remember seeing your username. I meant more from new coworkers and boss to counter the old employer's claims. I was tough to schedule and a bad employee. Sorry, it wasn't more clear. I was trying to make it quick. Thanks. Okay, so evidence that you're not difficult to schedule and a bad employee at a new job doesn't necessarily mean, like, I understand what you're trying to do. You're trying to like create an inference, right? But like, it's not very high value evidence if you think about it. Like, if you're working for a boss and your personalities just clash, right? Makes sense. You'd be a more difficult employee in that scenario. You'd be angry. You'd be dealing with a lot of stress. You might not want to go in. You might be harder to schedule. Like, it's just different. Different situations are different, and humans behave differently in different situations. So, like, the idea that you're presenting evidence that, like, I was a great employee at this new job where they treat me better. Okay, it doesn't necessarily go to show what happened at the old job, right? Choose Compassion, our moderator. It's good to see you. Thank you so much. NYC Damages says, I filed in federal court, NYC, but there's even more discrimination happening. Should I cover my ground and file for ongoing discrimination with the EEOC if it's not the same protected classes as my current complaint filed in NYC federal court? Okay, so I'm not going to tell you what to do, but you could investigate whether or not you want to amend and just bring those claims under the New York State and New York City human rights laws in your case. If you're pleading those, you could also make a decision as to whether or not you think that these additional events reasonably flow from your original EEOC charge, which gave you a right to sue letter, I presume, when you filed in federal court for those claims. Now, here's the issue. If it's new protected classes, the argument that it reasonably flows from the events you already pled is significantly weakened. So you might need a new EEOC charge, which you could file with a pull letter, asking for your right to sue, and then amend with the second right to sue letter. But you're going to have to, do your research and make your own decisions. I can't give you legal advice. I can talk around the situation, but I can't tell you what to do. All right. Hot One Records says, can I get a record deal? Hot One Records. I'll help you. You help me. Record deal. S'il vous plaît. What if I was injured on the job and my employer lied to their insurance and said I was a contractor? Then I was terminated and withheld my final paycheck unless they sign a mutual termination agreement. So it sounds like your workers' compensation attorney is going to have a field day with your employer's lies. Hopefully you didn't sign anything. But yeah, I mean, talk to your workers' compensation attorney about that workplace injury and about these lies. YouTube user Zay Menz says, I crushed my company in my rebuttal to the EEOC, but then a company has shut down settlement negotiations. Their position statement was pure lies. Any guesses to what the company is thinking? Yeah, they're waiting to see if you file. They're waiting to see if you file in federal court, or they don't agree with you that you crushed them in your rebuttal. Could be either one. Or listen, they just think you're asking for too much, right? They might want to offer you a certain amount of money, and you're asking for whatever it is, and they're just like, better to see if we just lose the case, right? Chat jumping. YouTube user John says, number one, if an employer's own law firm wrote a public article stating that an FMLA interference claim does not require a formal denial of leave, that discouragement alone may constitute a violation. Yet, two, the employer's position statement issued by the in-house counsel argues there was no violation solely because no leave was denied. Does that contradiction support a finding of pretext, bad faith, constructive knowledge? So listen, I don't know the details of what they're arguing, but like, those two things are not necessarily the same, right? So yes, I agree with the outside defense firm's article, which sounds like they wrote, stating that FMLA interference claim does not require formal denial of leave. True. I think unquestionable under the law. Now, you go on to say, like, well, then if that's true, how can they argue there was no denial? It's true that a formal denial is not required. However, it's also true that the lack of a formal denial does not mean that there was a denial, right? You need to show like, hey, there was an informal denial. There was reason to believe this would not be granted. Like you have a standard that you have to show under that proving of the informal FMLA interference claim, right? So they can say, hey, there was no denial, formal or informal, of any kind. So, the argument doesn't necessarily mean that you win. They're making a viable argument that you need to counter. LC, do you list the punitive damages in the initial disclosures? How do you calculate this? No, you can't list punitive damages because you don't know what they are because they're discretionary to the jury. How to choose compassion. NYC Damages says, how are you today? Heart lightning bolt. I think someone just started up an excavator right outside my window. Whoa, chat jumping on me. Berries, yes. I love berries. How good are strawberries? Can we talk about that? I got like 50, 60 blueberry bushes on my farm, and I got a lot of work to make sure they're all cared for this year. I got to go get them fresh compost and fresh wood chipping and do all the things. But I love just having a blueberry crop that supplies everything I want. I just throw them in mason jars, throw them in the freezer. Good for a year's supply. Love it. They freeze and thaw so nice. But anyway, I digress. Barry's Yes says, they want me to consider early mediation, EEOC. I selected undecided, retaliation, sex, protected, right. I selected undecided. I won't be much of an investigation. All my evidence is recordings. Okay. I don't know if that was a question, but like if somebody wants to talk about giving you money at mediation, go. And I would recommend maybe you watch our mediation preparation playlist. Yeah, why would you not sit around and listen to people try to give you money? You might not get what you want, but you're going to learn a bunch of stuff, and it's worth your time to listen to people be like, well, listen, we don't think you have a claim, but we would give you X amount of dollars, right? Like, it's still valuable. Might be frustrating, but it's valuable. YouTube user Jane Doe 1 says, my current attorney told me because I didn't accept a lowball settlement offer that wouldn't nearly cover my expenses, back pay, or any damages that I should find another attorney. Okay. I mean, that is unfortunate, but like it's possible that your case just isn't that strong or the damages aren't there, or it's possible your attorney is a piece of shit. Like I can't tell you which it is, right? But the question goes on. 2, I've already paid an upfront fee to the current law firm and I retained and have agreed to do a 25% contingency when they took the case. There are very few employment attorneys in my area, and my case is in the middle of discovery. What can I do? And do I have a good chance if I have to do this on my own? Okay. So listen, I would hit up our find attorney and evaluate an attorney playlist to like try to find local counsel. I understand you're frustrated. There's not that many. If you can't find local counsel, hit up the national firms. There's our firm, but there's us like Shigarian and Associates and Morgan & Morgan and Gloria Allred and a couple of others. And I'm not recommending any of those firms besides ours, but like, I'm not trying to like get you to call ours. Listen, use the evaluate employment attorney playlist, no matter who you're talking to. To answer your last question, do I have a good chance if I have to do this on my own? So there are people on this channel who are representing themselves pro se and it's going well. And there are people on this channel who have won or settled their claim while pro se. That is a reality. That can happen. That being said, 99 times out of 100, going pro se is just engaging in self-harm. It's just self-loathing. You're putting yourself through an incredibly difficult process and you're destroying your claims, and it is what it is. So generally speaking, do you have a good chance of doing this on your own? Not at all. I don't want to like be discouraging, but like if I had a family member who was representing themselves pro se, I'd be like, what, you hate yourself? Like what, like it's, I'm not going to say don't be stupid, because a lot of people are pro se because they don't have an option. And I'm sure that's why you'd be pro se, but like it's incredibly detrimental to your case, to your claims, to your chance of success. Again, if I had a family member come to me and like, hey, I'm gonna be pro se in this case, I'd be like, what? You hate yourself and you think I don't love you? You think I would not pay for your attorney, like, to keep you from just engaging in self-harm full time? And that is fully my view on pro se litigation and pro se litigants. And like, there are people on this channel doing it. They are the exceptions that prove the rule. I cannot stress enough. All right, we hit the 1 hour mark. We have 46 concurrent viewers and yet only 42 likes. Okay. YouTube user Viral Shedding Zombie, who, whoa, what is chat doing to me here? Let me go back. Let me go find Viral Shedding Zombie. Where is it? I found it. Viral Shedding Zombie says Vince likely has the resources to buy the Netflix Corp either with cash or farm eggs. I mean, listen, farm eggs are worth like $4 a piece now at the food bank. So, I mean, bit of an egg baron over here. Get my monocle out. I certainly would not be buying Netflix. YouTube user AB. What can I do if my previous employer added false accusations to my background report about an accident? I have a police report that states differently. I mailed it to HR, caused me to be terminated. I mean, do you think there's discrimination or sexual harassment in play? Some kind of retaliation in play? Was it workers' compensation retaliation if there was like an accident while you're on the job? Yeah, I would check with local counsel about your options to address that. YouTube user MYM said, my employer reported to unemployment that I committed fraud, but they're unable to prove where the fraud is. Good. So just, show the unemployment agency that you didn't. It should be fine. NYC Damages says, thank you so much, Vince. Should have worded it slightly different, but your advice probably helps everyone, knowing you can only talk in generalities. Thanks again. It's so helpful. I'm really glad it was helpful. YouTube user Kelsey says, Vince, my former employer denied that a complaint I made of being assaulted at work existed for almost 2 years during litigation. Then they ambushed me with it during my deposition. Is it unethical? No, I mean, it sounds like they thought it didn't exist, and then you turned it over in discovery, or they found it in discovery. So they questioned you about it, if I'm understanding the situation correctly. I don't know that's unethical. I think they're probably challenging, what happened. That's why they're asking about it now. YouTube user Laura Lee says, the fact I received unemployment benefits despite quitting help my constructive discharge claim with the EEOC? Sorta. I mean, like, listen, first off, the EEOC doesn't really decide the case. They're just going to give you a right to sue letter if you're a private employee. But that being said, like, it's somewhat useful if an administrative law judge comes to the conclusion in an unemployment hearing that you experience constructive discharge. Like, that has a value of sorts. It's not dispositive. It's not like, then this is what happened. It has been decided, to quote the league, right? That's not what we're doing. But yeah, it's useful. YouTube user TR. Whoa, chat jumping on me. YouTube user TR says, hello, thank you for doing this. I was wondering if there's anything I could do. My job let me go, and it keeps happening due to my fibromyalgia flare-ups along with my asthma. I'm also in the process of filing for disability with NASH. Well, I mean, listen, it sounds like if you're being fired due to your fibromyalgia, you have a claim under the ADA and potentially state and local laws as well. I would check with local employment attorney right away and potentially bring that claim. YouTube user Annie Lynn says, Vince looks great, refreshed. Annie, thanks for noticing. Barry's yes, because they will have to pay me a very big bag. Mediation is Dollar Tree money. I'm taking them to the Gucci store with my evidence. LOL. Yeah, you have a fundamental misunderstanding of mediation. So, I mean, you may not want to settle the case in general. You might be saying like, hey, I don't want to engage in settlement talks because I don't want to head for risk. And I feel very confident about this case and I want to go to trial, in which case I misunderstood you, and great. But that being said, like, I have attended mediations that changed the course of my life and changed my tax bracket and the tax bracket of my clients. Like the fact that you're at a mediation doesn't mean that the dollar amounts are lower. That's not the case, right? I mean, we got a farm here. It's nothing fancy, but we got a farm here that is essentially the result of like a fairly good day in a single mediation, right? Like, so, don't slam mediation too hard. All right, short break. All right, we are back. YouTube user reclaiming your life says, so I am currently suing my ex-employer, Title VII, ADA, and state torts. Would it be too aggressive to file a second complaint of RICO, 1981, FMLA, and FLSA? I don't know. I don't know what happened in your situation. RICO, civil RICO claims, like I've seen it done. I've worked on them. They're extraordinarily rare, and that could be viewed as an extraordinary tactic. Now, if you have viable 1981 and FMLA and FLSA claims, I don't think it's too aggressive to file them. Like if you can add them to that action and they're viable claims, why would you not? But that being said, the actual viability of those claims, like if you're like filing FLSA because, the Fair Labor Standards Act, you're like, well, I should have gotten paid more, right? Let's turn on the light. I got no light going on back there. What's going on? It's amateur hour. So, I mean, the question is really answered by the facts of your case, which I'm not privy to, and I'm not going to become privy to on a live stream. So, not necessarily too aggressive if the facts fit, I guess is the answer. YouTube user LC, what defense could an employer use for promoting an employee on multiple occasions without any relevant experience or education? For example, director of HR with no HR training, experience, or education. What defense could they? Yeah, he or she does a good job. Okay. That's a defense. But they have no training, no education in HR. Yeah, but they do a good job. Or even, yeah, I thought they would do a good job. Or they've been doing a good job, so we just kept giving them more. Or, yeah, we couldn't afford somebody with specific HR training. So we went with a known commodity, right? Like, it's not like not having HR training necessarily makes you incapable of doing HR. Like, most people in HR don't have HR degrees. And a lot of them are making, in big tech, like $450K a year. So, I see that all the time. So, it's not necessarily damning that there's not like a specific major in HR during their education or something like that. NYC Damages says, do large companies have more than one person to serve the company? In general, where do you find out who is the designated person to serve the company? Well, okay. So I guess the real answer here is if you're having trouble with service, hire a process server, right? Like we can get into how you might serve a company, but like, oh, hold on. I am pro se and I do this full time for the past year, waiting for the EEOC, flawed services, aka time wasting. Okay, so you're saying you're a process server? I mean, if you're a process server, you would know the process. But generally speaking, in terms of serving corporations, there's usually a set process. that a process server can abide by if they're doing service that way in each state. If you're looking to do waivers, like waivers of service, and you're wondering who to mail them to, just mail it to the general counsel. Generally is a safe bet. You can also the head of HR, like there's plenty of options. They might on their website designate someone, but like you can't go wrong sending it to the general counsel. YouTube user Secret Dad says, I have Ring cameras in my residence. If they recorded phone conversations on speakerphone, or can they be used in court? Could they be used in court? Depends. Depends on the rules of the jurisdiction you're in. Depends on what was recorded. Certainly possible. Okay, YouTube user David Almendara says, Vince, if an employer didn't follow any of the FRCA, which would be the Fair Credit Reporting Act violation, I guess you mean they didn't follow any of the rules, can they still use your background check to disqualify you? I would think no, because I think that would give you a claim, but I don't know off the top of my head. I suspect no. I would check with an attorney who does credit reporting stuff. For wrongful termination claims with respect to things like wage and hour and union organizing, is reinstatement more or less likely to be considered an equitable remedy? Generally, employers are not excited about reinstatement. It can be done. We've certainly done it many times. But generally, because of the liability of retaliation claims, they're very reluctant to do reinstatement. They'd rather pay out cash. YouTube user C Anonymous says, does it help when an employer changes or alters any disciplinary actions in any way and submits it as evidence? Yeah. If you can prove they're altering records of discipline after the fact, I think that's often going to be a huge hit to their credibility. And I think that would be valuable evidence for you to present. The Internet OG says, I'm at the end of the investigation. They're requesting one more letter from T-Mobile, and then sending to the law team or whatever she said. I know my case is strong. How long until I see a settlement? I don't know. I don't know. I don't know what you're asking for. I don't know if they want to pay. I don't know if you're going to trial. No clue. No ability to answer that question based on the information presented. I also I don't know like how liquid they are. I don't know what jurisdiction you're in. There's a lot of unknown here, right? I'm not to be flippant about it. YouTube user C Anonymous says, if an employer admits during mediation that they never investigated your charge, does that help with anything? I mean, were you there? Like, were you working there when you filed your charge, or did you already leave? I guess is my question for you. YouTube user Sonia Underwood says, wow, this is the best chat live ever. The likes are fire. Keep it going, y'all. Smiley face, exclamation point. Sonia, thank you so much. We are at 51 concurrent viewers and 51 likes. And thank you all so much. I didn't even shave for this, so thank you. I'm just over here trying to make up for not doing this during the week before I go do my thing on the farm. Whoa, chat jumping on me. Chat jumping. We were about to answer a question, I think, for YouTube user Kelsey. YouTube user Kelsey, is it violating settlement confidentiality if you tell someone that the case settled? Depends on the terms of your confidentiality agreement and your settlement. I can't answer that without reviewing your settlement. You can always ask your attorney as to what you agreed to. Certainly. YouTube user Pascal Mexinow says, hi, Vince. How common is misrepresentation like falsifying an offer letter? I don't know. I don't think I've seen too many fake offer letters in my day. but maybe they just don't come to me. Maybe because it's really easy to fake an offer letter and then not honor it. Like they happen all the time and I just don't know about it and they don't go to litigation. All right. YouTube user Akron Hammer. Now, real pause before I even read your question. I don't know if that means something. I don't know if the Akron Hammer is like a character or a thing, but I'm just imagining you as like this vigilante in Akron, Ohio, who goes around being like, I'm the Akron Hammer and hammer and like running around and like righting wrongs or something. If it's something else, then I'm bummed out that I didn't know that. But like, that's how I imagine things when I read your name. If a similar situated employee committed the same or similar offenses and one employee received a suspension and the other was terminated, does the terminated employee have grounds for a case? Maybe. So you can make a disparate treatment argument. You go on. Disparity in treatment. Yeah. So like if you think that one of those two employees had membership in a protected class and that's why they were treated worse, then that is potentially a discrimination case under a disparate treatment argument. YouTube user Alan Agnew says, hello, Mr. White. Hello, Mr. Agnew. In an FLSA, a Fair Labor Standards Act overtime case where an employer paid an electrician a salary of $640, 16 times. Hold on. What electrician is getting paid $16 an hour? What part of the world are you in? Are we sure that's the part of the world where the FLSA applies? 2023 in Texas. Alan, you want to come to New Hampshire in 2025 and just be an electrician on your own? People would currently be paying you $450 to $650 per hour. I'm not kidding you. Like that is the going rate for an electrician in New Hampshire right now. Like I had to get a charger for my EV. I used to have an EV truck. Now I guess I still have an EV truck. I have a different EV truck. And like got very lucky, met a very cool dude who was working on a solar deployment that we had and helped install the charger. But like I paid a guy double rates to drive like 2 hours to come do the installation here. And he basically was like getting paid twice my hourly rate. So like hundreds upon hundreds of dollars per hour wasn't even really worth my time. And then he didn't really do the installation correctly. Like I literally handed him like the technical specs and like how this had to be correctly installed from the manufacturer. And he was like, don't need it. And then just proceeded to install it wildly unsafely. And then the guy who did the solar install was like, holy shit, this is not working and it's dangerous. And he like fixed it for me, like kind of on the fly for free. Cause he was just like a mensch. He's just a good dude. Really great guy, super likable. But anyways, you should come to New Hampshire, Alan. Our winters are a little different than Texas though. Okay. Now I digress. Let me go back to your question. Hello, Mr. White. In an FLSA overtime case where an employer paid an electrician a salary of $640, $16 times 40 hours a week, but was not paid overtime for hours worked over 40 hours, my lawyer is saying the damages owed are only $8 per overtime hour not paid for instead of 24. Is that true? Okay, so let me understand this. You were working more than 40 hours in the 7-day period at a rate of 16 per hour for your standard rate. So your overtime should be time and a half under the FLSA. So you would have the argument that for every hour in a 7-day period worked over 40 hours, you are due not $16 or $8, but in fact, let me check my math here. And it's ridiculous that I'm checking my math, but I just want to make sure I'm not being a fool. Yeah, you're correct. $24 an hour. And further, I would make the argument that you may have additional increases of damages based on the behavior of your employer that might actually cause you to make an argument that you're owed more than $4 per hour for those unpaid overtime hours. Okay, YouTube user Jay Scion says, can we email you questions? Super duper no. Yeah, not at all. I'm getting 30 to 50 emailed questions a day, and we just delete them all because I don't have the bandwidth to take care of them. You have to contact other attorneys. I get it. I get it that I'm the guy on the internet who like somewhat makes himself available. And you're more than welcome to talk to our intake people if you want to, discuss with our staff about potentially hiring us. Thrilled to have that conversation with you, but we can't do free personalized ask and answer. We're at the point now where I would have like 3 attorneys working on that full time, which the cheapest that could possibly be is like, if I had 3 attorneys working on ask and answer full time, like if I was getting the cheapest of the cheap baby first year attorneys that were still training, I don't know, 320, 360K to answer questions. Like it just isn't viable. We can't do it. Other attorneys are going to have to step up. Other attorneys are going to have to open YouTube channels. Like other attorneys are going to have to answer questions and do free consultations. We're doing what we can. I'm sorry, Jay. It's just not viable. So the answer is, in fact, super duper nope. Yaya Tube says, excuse me, getting lightheaded. I'm coughing so hard. Yaya Tube says, how long should summary judgment take? Like from the time someone asks for leave to file a summary judgment motion to the time it's decided? 4 to 8 months, 4 to 9 months. Can take longer. It can certainly take longer. David Almendarez says, if the company clearly didn't give you a chance to dispute your criminal record. Okay, so we're about the criminal record, not the credit part. After there was an error, does this make a good disparate treatment claim? I mean, I think you might have a perceived criminal record discrimination claim. I don't know if a disparate treatment claim is in play. It could be. The Akron Hammer says, spot on. He is in fact a vigilante, and that's amazing. Isaac's Trade says, Vince, my guy, how are we doing this beautiful Saturday? Better than I deserve. Much, much better than I deserve. I have far more luck than any single human is due. And thank you for asking. I hope that you are doing well, Isaac's Trade. YouTube user Ladybug says, what animals do you have on your farm? Right now, we have egg-laying chickens, 5 asshole roosters that we keep currently separate from the chickens, and 6 pigs, 3 in a breeding trio with a breeding boar named Pigatoni, and then 3 young pig lads who will, have a very good year and then potentially rest in the freezers from somewhere around December or so. But we're getting about 100 Freedom Ranger breed meat birds, roasting chickens. In short order, we're getting, I believe, 30 turkeys this year of a northeastern variety. Really considering some miniature Scottish Highland cows. Real passion of mine. I want cows. I want milk, but I don't know if like we as a farm are ready to handle full-size cows. Like we don't have a depth of knowledge about cows. We kind of like went real slow with pigs because pigs are cool, but they're not like without risk. So we went real slow, learned a lot of things, learned a lot about training them to electric fence, got relationships with vets, got relationships with local breeders, got really got to know like the feed situation and everything. So we try to go real slow. So I'd probably pay extra for the very cute miniature Scottish Highland cows because their disposition, from all of my research, is incredible. Like a 5-year-old can lead them around. That's how chill they are. But also just learning to milk, buying like a small milking machine and applying that, learning to inseminate and like, having the vet come and do all the things and learning to rotate, them. I think it would be nice to learn on a miniature cow. And I also think like, I understand everybody's gonna be like, oh, the beef isn't efficient. You're not getting efficient beef. and you're not getting a ton of milk. For their size, you actually get a lot of milk. And I don't actually need that much milk. I just want milk for my own cows. But because emotionally, I do. I could just get milk from my neighbors, but like to me, I'm like, I want my own milk, and I'm out of things to buy. So milk cows. But people are like, oh, it's so efficient to get the miniature Scottish Highland. It's not, it's not good. It's not good. I don't have that much land. I mean, I'm kind of angling to buy my neighbor's place, but like, unless that pans out, I don't have that much land. It's like 11 acres. So the miniature, really lets me do a lot more with the pasture available to me, and lets me learn more. So we're thinking about going that route. Alan Agnew says, maybe if I get that 50 state license, go anywhere. Yeah, Alan, you should. So I can't stress enough getting access to any talented tradesperson in New Hampshire right now, because people are just moving here full time from like Boston and New York, and a lot of the like cities that had like a massive kind of like a brain drain or a money drain during the pandy. We'll be careful what we call it because we don't want to get demonetized here. So tons of people came, so tons of houses are getting built, and they want roofing crews and framing crews and finish carpenters and electricians and plumbers. There's just not enough, not even close to enough up here. Okay, YouTube user Jay Scion says, the employer terminated me due to missing days, but I was approved by FEMA for a storm on May 17th in Houston. Also took a prior leave of absence, returned with accommodations for weather-related reasons, and isolation to focus came back to sex rumors and a call center management. One was termed sex in the bathroom. It sounds like you have a gender discrimination and sexual harassment case, to be honest with you. But kind of what I'm hearing here. Isaac's Trade says, God damn, that's wild, electricians that valuable in your area. Yeah, Isaac, it is tough. Like, if you want to get an electrician to show up, I would suggest having $500 in cash just to get them in the door. If you're in upstate New Hampshire, and just accept that you're like getting them in the door, and then you're still pitching them to like, and I really want you to do the work. It's worth my time. You're double your rate. Like, and they'll still just be like, I don't know. So you really got to kind of know somebody. We're very fortunate. We know somebody now. That will be done, says, hi, Vince. If your employer admits they refused to speak to you and ignored your emails during litigation, I'm still employed. Can that be evidence of ongoing retaliation? Yeah, I think that can. I think isolation and disempowerment and lack of access to authority and lack of opportunity can all be characterized as retaliation. Rock the Grouch. YouTube user Rock the Grouch. I feel like we're doing like a Rock the Casbah thing. Rock the Grouch. Rock the Grouch. Anyway, always love these lives. Thank you, Rock the Grouch. It's very kind of you to say. One of the most helpful online. Still deciding to pursue a claim of my own as no attorney will take it, or just let it go. Hard to tell discrimination from just horrible supervisors. It can be. I hear you on that. If there's something we can chat about here to help you, we got 30 minutes left. I'm not going over 2 hours, but I'm going long today. I'm doing a full 2 hours today. So hit me up. Let me know. YouTube user Alan Agnew says, it could happen. Okay. Sounds good. LC says, I did not hear back from your intake attorneys. Do I just assume your firm does not want my case? Listen, if you contacted us, they should have responded to you. I would check your voicemail, check your email, check your spam folder. Generally, our intake staff respond to everybody who's not doing one of two things. One, sometimes people sound very unwell, very, very unwell in their messages to us. Like, If you're contacting us like, hey, I think I'm gonna have a discrimination claim, but I really want to peel the skin off my boss, we're good. You're not gonna get a response. It's just I'm not gonna put my staff through that, like, and I get the impulse for revenge. I'm not saying this is something you're doing, Elsie. I'm just saying, like, in that hypothetical, we don't want to talk to you. It's like that Eminem song where it's like, this kind of stuff makes me not want to know you. Makes me not want to meet you. So that's one thing that could be happening. I'm sure that's not what you're doing. Also, listen, people just will like get in our chat or call our intake call center or whatever and just start hitting them with questions. And the intake people are like, yeah, this isn't an ask and answer. Like, you're trying to hire a firm. We're happy to hear about your case, but we're not a free ask and answer for you. We're not attorneys. We're intake professionals. We're not allowed to give you legal advice. We're not answering these things for you. So if one of those two things happened, you're just not going to get a response from us because obviously, and Elsie, I'm not saying anything like that happened with you. I suspect with you, because you seem very reasonable, what happened is you contacted us and you might have left the wrong email, the wrong number. They tried to contact you, or they left a voicemail, or they sent a text message, or they shot you an email. Maybe it went to your spam folder, whatever it is. But we should generally be getting back to you. If it's just a case we're not interested in, we tell you, hey, thank you so much. It's not a case we're going to make you an offer on. So, we should be getting back to you. YouTube user Amen King says, I have a wrongful termination and a retaliation case. My former employer has fired most of the people involved. Does this help my case in the New York State Division of Human Rights and my case as a whole? Listen, I don't know the specifics of your case, but if they fired the people involved, then there's a chance that they're not going to be able to turn those people up as witnesses later on. So if you can turn up your key witnesses and they can't turn up their witnesses, maybe that's a big benefit to you. Choose Compassion says, we need a live stream to talk about the farm, not 5 asshole roosters. So yeah, these roosters are like, no bueno. No bueno. It's really funny. Like, they live in fear of like certain humans because like one like leapt at me and I like snatched him out of the air. And he was just like, oh, this is how I die. All right. And obviously I didn't kill him. I'm not looking to engage in animal cruelty, but there's other people who are like, they flee the rooster, and then the rooster's like, aha, I gotcha. And the rooster's like chasing and they become empowered, and they're, it's just like creates problems. So these roosters, they're going in the freezer. There's one that's like really beautiful and like really actively engaged in like protecting the flock. That will probably make the cut, but other than that one, like the other 4 are freezer bound. Okay, YouTube user LC says, trying to figure out how long my trial should be. Depends on how much evidence you're presenting and the other side is presenting. I have lots of witnesses, but small contributions. What's the shortest time someone needs to testify? Can they do it in less than an hour? Yeah. Listen, if you have a witness who knows one thing, call them. They get sworn in. You ask them the one thing. They answer the question. The other side crosses them. You don't need a redirect. There's no recross. You don't redirect. Great. They're out in 45 minutes to an hour. YouTube user Jay Sion says, they also attempted to fire me in June 2024, but retracted, I suspect you mean, due to disability paperwork turned in late by Sedgwick. Sedgwick is such a piece of shit company. How can I get those recordings through settlement talks? Excuse me. During these 2 to 3 weeks to get reinstated. Well, I mean, I guess you can ask for those documents if you're engaged in settlement talks as like a pre-settlement disclosure or pre-mediation disclosure. You don't have a right to them necessarily, depending on the jurisdiction. Check local counsel. But you don't have a right to them until discovery hits in most jurisdictions. YouTube user, the unaverage Joe. Ooh, the extraordinary Joe. I strongly suspect my phone has been hacked by coworkers. They mention and say things in the office that they couldn't possibly know unless they had my phone hacked and they were using it to surveil. I'm really sorry to hear that, Joe. Oh, Alan Agnew says Joel Salatin. I'm a huge fan of Joel Salatin. Is the inspiration for many to go into farming. Nice and organic. Don't need to be efficient. Having happy animals is better. Yeah, I don't feel the need to be efficient. So I do want to set up systems kind of like in the Joel Salatin way. Like I want my chickens to work my compost. I want my chickens to follow my pigs in pasture and like clean up some of the waste and work the waste into compost to fertilize the pasture quicker. I want the chickens to follow the cows that I'm hypothetically going to get soon so that they work over the cow pies and make sure that fly population is not getting too out of hand, right? And just creating better pastures, grass that sequesters more carbon, because I fundamentally believe in climate change. And I know it's like political, but like I believe in climate change. So, if you don't, that's fine. I'm not saying you have to, but I do. I don't believe that like correctly handled livestock are the reason for climate change. That to me is ridiculous because there's fewer ungulates in the world today than there ever has been in the entirety of human history, at least. And so when you're like, oh, it's the cows causing climate change, probably not. It might be improperly fed cows that are eating grain and corn that their stomachs are not properly adapted to digest when they should be eating grass that sequesters carbon, right? So like, yeah, listen, factory farming of cattle might certainly be the cause for climate change. So stipped. I think it's entirely, reasonable to say that. Properly rotationally grazed cattle? No, probably not, right? Probably not the case. So like when I'm like, I'll be like, yeah, I think we're going to get some cows. People are like, that's disgusting. You're contributing to climate change. Okay, well, you're flying private, buddy. I know you. You invited me on your private plane last week. I think I'm doing okay, but yeah, I'm a huge fan of Joel Salatin. Really like the content. Really big fan. Listen, he's got some other stuff going on. I think he's got some religious thoughts as well. But I think he's a tremendous farming and homesteading educator. Real value, and you don't have to like everything about someone to like them in general. This is my take. Jay Salus says, hi, Vince. Hope you're doing well. I hope you're doing well, Jay. Amen King says, just asking, is there a time limit on how long a case can take? So every managing, like if you're in federal court, the federal court system where you are has like a managing judge. That's going to like have times and standards for how long cases take. And that's going to apply pressure to judges to get their cases done within that time period. But no, I don't think there's like a hard time limit on how long a case could take. YouTube user Ladybug says, please start a channel for your farm. There's actually a lot of content like that out there. And I'm not really the most knowledgeable farmer. Like and when I say like my farm manager and our content would be like of us bumbling and us figuring things out slowly, right? Which might be funny, but it's not very educational. So I don't know if that channel has the same value in the world that like a Joel Salatin's channel would, where he's like, yo, I've been doing this for 50 years and like I have thought of 17 different ways to do it, and this is the best way, and here's the proof. Okay, that's quite the pedigree, right? That's worth watching. Me, it's like, yep, I'm like, my farm manager made a video the other day. He thought he lost a pig. It was right there. He just looked like a boulder, laying down. He's just chilling. He's having a nap. He's freaking out, panicking because he thought he lost a pig. And then he looks over. He's like, God damn it. Is that the pig? Just laying there on the ground by some other boulders. And it's like, that's the level of like what we're doing in many ways. YouTube user C Anonymous says, hi, Mr. White. I am currently still working for the employer who had admitted to not even investigating my grievance or charge during mediation. Can that information be used against the employer? Maybe. Could be valuable evidence. Isaac's Trade says, run them likes up, chat. Let's show Vince how much we appreciate his knowledge. Oh, that's very kind of you, Isaac's Trade. Thank you so much. We have 52 concurrent viewers, 62 likes. Thank you so much. Jay Salucci, 176 says, I was wrongfully terminated after coworkers called me retarded. I'm so sorry. And not meant for the job. I have an autism diagnosis and they haven't given my final pay. I'm so sorry. That certainly sounds like an ADA claim. I'm really sorry that was done to you. I would speak with a local employment attorney right away. NYC Damages says, can you talk about how to use the employer's lies that led to firing, like retaliation? Lies you can prove in court, for example, documents say different things, position statement and deposition. Yeah, so NYC Damages, we have videos about like rebuttal writing 101, in which we, really urge you to treat your employer's lies as opportunities. We have videos about pretexts, like pretexts for termination, lies leading to termination, and how to deal with those. I would hit up those. I think those are going to be much more long form, much more built out than what I can supply you in the live stream today. Mr. 3000 GT, love me a 3000 GT. Hearing is Friday. Good luck. Wish me luck. And my birthday is today too. Happy birthday, Mr. 3000 GT man. I hope all is going well, and I wish you great luck at your hearing. Amen King says, thank you. Amen King, you are welcome. Carol Mosier says, good morning, Vince. Why would an attorney continuously delay and go slow on a case? For example, waiting until the end of every deadline to file. I don't know, and I rage when they do this. I don't like it. Defense counsel might have a reason to delay. They want to bill. But when plaintiff side attorneys do it, it's just self-harm. When I find like an associate slow playing their case slow because they want to like take life easy, out the door. It's just not viable. Like, you got to move cases. You got to be aggressive. You got to apply pressure. That is how cases get settled. That is how cases get pushed and won. And employers freak out and do stupid things, like you're creating some level of chaos. And that chaos is a ladder for your claim, for your client, for the benefit, right? And letting the case sit or letting it be delayed, to me, is an act of self-harm towards the firm. It's not good service to your client. I don't think it helps anyone but the defense. So they do it because they're tired and because litigation is hard. That's why attorneys do it. But like, you got in the game. If you don't like playing the game because it's too hard and it's too tiring, too much stress, okay, you had a good run. Get out of the game. It's over for you. Right? I mean, that's the reality. And listen, I've had that conversation with a bunch of attorneys. People are like, listen, I just can't get after it the way I used to. Okay. Maybe it's time to go defense side. Maybe it's time to go in-house. Maybe, lots of employment attorneys get hired in-house for various reasons. And the quality of life for in-house attorneys can be like a lot better. The money's not necessarily the same. An in-house attorney can do really, really well. I'm not saying they can't. And listen, the highest of the high, they make big money. But generally speaking, plaintiff side employment attorneys who are good-ish, even good adjacent, are going to be doing a lot better than some in-house attorneys, right? But the quality of life is really great for some companies, right? Not all. All employers are different. But I've had that conversation. Like, listen, you don't got it anymore. I'm not going to fire you, but like, you can do it right or do it somewhere else, and you got to do it. You got to do it. Like, it's not about the attorneys, right? Like, if you can't bear the burden, take a walk, put somebody else up there, Choose Compassion says a rooster gets pardoned. Yeah. Un rooster gets a pardon. To la mort to quit. Oh. What happens if a lawyer was negligent and caused me to miss the statute of limitations for discrimination? Is there statute of limitations on whistleblower retaliation? I have a misclassification lawsuit that was just moved from state to federal court, and I've heard from an ADA advocate that a motion can be filed that could extend the statute of limitations. Okay. So if your lawyer engaged in negligent behavior that caused you to miss the statute of limitations, your recourse is potentially a malpractice claim against that lawyer. There are many statute of limitations that govern whistleblower retaliation. Different whistleblower claims are covered by different sets of laws. Some are state, some are federal, some are local. So I can't answer that question. You have a misclassification lawsuit that was just moved from state to federal court. And I've heard from an ADA advocate that a motion can be filed so I don't know why an ADA advocate is advising you about a misclassification lawsuit necessarily. And I don't know the context of which they're arguing that you could extend the statute of limitations. If you want to get something in writing from the ADA advocate and comment it on the channel, I can address what they're saying. Happy to do that. But like, a random ADA advocate who sounds, because when you say ADA advocate, what I hear is probably not an attorney, saying the statute of limitations can be extended. I'm like, okay, what are you saying specifically, right? Like what are they actually saying, right? You know, and do they actually know what they're talking about? YouTube user Millie J says, can I file a complaint with the VA if my application was denied to care for my father? Do you work for the VA? I mean, I would imagine you have Family Medical Leave Act rights. So if you work for the VA, then potentially, yeah. Thy will be done says, thank you. In regards to summary judgment decisions, are judges in specific circuits generally consistent with how they interpret the law? No. Is it helpful to review recent opinions? Yes. So you're going to want to stick to the opinions in your district if you're dealing with the federal courts. And then if none of the decisions in your district are on point, if they're not useful, you might be forced to expand your search to other districts, but that is going to carry much less weight in terms of the value of that case law precedent. So like that is tough. John Pleasant said, is $120,000 unrealistic ask in a mediation for wrongful termination retaliation claim? I don't know. I don't think about your claim. Why don't you go hit up our damage calculation playlist? That gave you an idea if it's realistic or not. I can't do a damage valuation for you because I don't know anything about your claim or what you earned or if you're treating or any of that. And we're not going to be able to do a damage calculation on this live stream because that's going to take like 3 hours. So what I would recommend to you is hit up that damage calculation playlist and get a feel for like, hey, strength of my claims, the valuation of my damages. Is this like a reasonable ask? Boom. Sahid Patwari says, I was terminated by my company because of poor performance. I never received any indication of poor performance stated in my mid-year and yearly review. So listen, they're not required. It's not a law that they have to engage in step discipline and give you warning. Unless you have it contractually, right? If it's you're subject to a collective bargaining agreement or you're a municipal or a state or federal employee, often there might be something in place where you do need to get step discipline, warning, a chance to reform your behavior, stuff like that. But if you're just a private at-will employee, in most jurisdictions, there is no requirement for step discipline. Check with local counsel, obviously. If you think discrimination is in play and that the claim of poor performance was a pretext, talk to local counsel about that claim. Amen King says, the New York State Division of Human Rights has my case on hold for investigation. It will be 2 years that New York State has my case. Is that normal? I think that's pretty normal for unrepresented people. Yeah. All right. Choose Compassion says, I think this is the hypothetical opening for the farm channel. Hi, I'm Vince White and I'm an attorney, but not on this channel. Okay. What do we got? I'm taking a break. We've been going an hour and 15 minutes now. Taking a break. Like 10 minutes left. All right, I'm back. Let's finish strong. 47 concurrent viewers, 64 likes in the stream. We've been going for an hour and 49 minutes. We will go a couple minutes more. YouTube user Kelsey says, what are your thoughts on mandatory mediation? Are they generally successful mediations? The general success rate on mandatory mediation is lower However, I think the value of the mandatory mediation program is without question. It keeps the courts from getting clogged, and many claims do get resolved at that mandatory mediation. It's just that mandatory mediation is less likely to generate a settlement than voluntary mediation. Because, in voluntary mediation, both parties are saying, yes, we would like to attend a mediation. In mandatory mediation, both parties are saying the judge says we have to be here. So you have a different success rate, right? All right. I'm just kind of skipping around now because we're running out of time. YouTube user OC House says, thanks for live streaming. Got a probable cause determination for my discrimination retaliation claim. Amazing. I'm really glad to hear that. YouTube user Robert Safari says, hello, can we just ask you a question? Yes, Robert Safari, you can ask me a question on this live stream. You cannot ask me a question in person. I do not have the bandwidth to answer private one-on-one questions. You can contact our impact people if you want representation, but if you're just looking to ask a question, type it in the chat right now. I'll get you an answer. YouTube user Mimi T said, can the new regime force a federal employee out of a remote position where they are hired for? In many cases, yes. There's no fundamental right to remote work if it's not remote work that is granted due to an accommodation of some kind. The position was advertised as remote. Now rescinding with reassigning to in-office duties. Yeah, I mean, listen, in many cases, they can say, hey, that position was previously remote. That position is now something we need in office. And that will often be legal. Aristotle Rush says, after receiving the RFP, the RFA, and interrogatories, when should you share that with your client? Please, can you, listen, if we get discovery demands, we share them with the client usually within 24 to 48 hours because you want to be collaborating on that, right? What is the worst case scenario for what? I don't know what you mean. YouTube user, that will be done. The defense consistently refused mediation, but after completing the pretrial order, the magistrate judge ordered mediation. Is that a, is that a good sign for summary judgment? No, I don't think it's good or bad. So listen, that mandatory mediation might be, hey, this summary judgment motion go either way. If the plaintiff wins, we're going to trial. If the defendant wins, claims are getting dismissed. I think you both should think real long and hard about this and settle. So I don't think it's necessarily a good or a bad sign. Aristotle Rush, we have videos in the, I'll read the question. What are examples or signs of lawyers selling you out? So we have a number of videos on the channel about case flippers. I think a lot of them are in our Evaluate Your Employment Attorney playlist, which Choose Compassion can post down below because Choose Compassion is one of the greatest moderators the world has ever known. But let me get back to your question here. Lost my train of thought. Greatly gifted. Ask your question again. I don't mean to stick. I'm not skipping you on purpose. Chat jumps around on me, and the longer chat gets, the bigger the jumps are. I was answering a question that went away. Okay. Okay. Greatly gifted said, can LCA supersede the BLA? Can LCA supersede? You write stuff out, dude. I don't know what you're talking about. Give me a little bit more. Robert Safari, I have 3 motions for summary judgment as a pro se litigant. I have 3 motions for summary judgment as a pro se litigant, and defense failed. Why would you have 3 motions for summary judgment? Are you filed 3 motions for summary judgment? Okay, Robert Safari. This makes no sense. You seem to be saying that you have 3 motions for summary judgment open as a pro se litigant. I don't know why that would be or what's going on. Then you seem to be like, well, they failed to file separate statements or provide evidence. I have no idea what you're doing. Nothing you're saying makes sense. Check with local counsel in California as to what you are procedurally doing to see if you're doing something correct or incorrect, and ask them about your options for default. But Doesn't sound like you're getting default, based on what you're telling me. Yeah, but your multiple causes of action are all in the same lawsuit, are they not? Like, do you have 3 separate lawsuits or 3 separate motions for summary judgment? Like, your motion for summary judgment can include you seeking summary judgment on like an unlimited number of claims, right? Yeah, Robert, I got to be honest with you. You sound like you're out to lunch on this one. This doesn't make any sense. And I'm not trying to make fun of you here. Check with local counsel. Like, you need to have a conversation with an attorney because I'm concerned for you in terms of what's going on in your case. This conversation where you like have 3 separate motions for summary judgment going because you have separate claims in the same action and they only responded with 1 motion and you think it's a default, like, it's not going well. And I'm sorry, I don't mean to be critical, and I know this is not your job, I presume, right? So yeah, check with local counsel. If you have the access to a pro se support office, get in there immediately, like first thing Monday, and talk to them, because this sounds, for lack of a better term, like a bit of a clusterfuck. Okay? And I'm not trying to be critical here. I want you to, it sounds like you worked long and hard on this. I want you to be able to win. It does not sound like default is in the cards, but you got to check with the California-based attorney. Obviously, procedural rules are different from jurisdiction to jurisdiction. I'm not allowed to advise you as to the procedures of California state courts, so check with the California state attorney. Yeah, check with the California state attorney. I'm not gonna be able to answer that. Okay, greatly gifted. Let's go back to you. Can I sue my employer if someone at my job had a worse situation than I did, but we both received the same time frame for our LCA? Okay, so if I assume you're suing your job for the either workplace discrimination or workplace sexual harassment, the fact that somebody had worse treatment than you doesn't mean that you can't sue to address the treatment you received, right? Like, if you experience discrimination or sexual harassment, somebody else, like if you're sexually harassed every day and it's bad, but like your coworker got sexually assaulted, that doesn't mean that you can't both sue, or that you can't sue and she, because she didn't sue, right? That's just not, there's no comparative, you can't lose your claim because comparatively yours was not as bad as someone else's. Like, she can make her own decision whether or not she wants to pursue her claim, in the same way you can make your decision as to whether or not you want to pursue your claim. Don't worry about that. Yeah, Robert Safari, I don't mean, I feel like I was probably like not giving you good news there, and I'm sorry. We do want to hear more. I would love to hear about your conversation with the Pro Se Support Office. Certainly. Ladybug says, how does your brain stay so sharp? It does not. My brain is not sharp. I have a very narrow practice, right? So we handle, really, I spend all my time in workplace discrimination, workplace sexual harassment. That is a very narrow field. So I'm able to sound like I'm really, really good at something because I try really hard to know everything within that range, that narrow range, right? Like, I am an employment attorney and I generally know about employment law in general. But if you're like looking for a 3-day seminar on the Fair Labor Standards Act, I'm not your guy. I got a guy for you, right? We have someone here that we could have teach that seminar who I would go to if I have FLSA questions. But I'm really spending my time on workplace discrimination, workplace sexual harassment, and running a firm, right? And knowing what good attorneys look like and making sure the attorneys are having the resources they need and they're doing what they need to do for their clients, and, you know, stuff like that. A lot of my job is creating content, but it's also choosing cases and engaging in quality control, making sure that the attorneys here are service-minded and keeping their eye on producing the results their clients actually want. And they're listening to their clients. They're engaged in a collaboration with their clients, right? That's hard because you have conflict-oriented, really good attorneys are conflict-oriented individuals in this field. And it's easy if you're conflict-oriented to bring that to all parts of your life. That's why so many of them are divorced, right? And they can have conflict and then bad things happen and they get to, you know, whatever happens. So you got to have quality control is my point. All right. We are over. Last question of the day. What do we got? Soul Sister Cuisine. Finish your question so I can answer it. Choose compassion. Question: if you think your attorney doesn't have the full story, how to best communicate with them without seeming unwell? Like a prospective attorney that you're trying to hire, try to get everything in a quick elevator speech pitch. After being pro se. So like you are pro se and you're now working with an attorney, get it in writing, put it in an email, make sure they review it, right? That's the most efficient way. Yeah, certainly. And if you're trying to hire an attorney, elevator pitch. World Travel says, will former law firm employer with 9 employees and 8 partners be considered 15 plus employers for ADA and Title 6, Title 7? Yeah, I think you have really strong arguments that employer will hit the threshold. Remember that in certain situations, owners count, vendors can count, in certain situations of counsel can count. There's a lot of things you can do to hit that threshold. So listen, I can't tell you will they, won't they qualify, but there's a really good chance that they might. So check out the specific situation. All right. Soul Sister Cuisine says, and I'm answering this question, hop at me because I love your username. If you have a current case and you filed for a reasonable accommodation or denied, can you add that to your case under the ADA? Yeah. Especially if it's an EEOC, just amend. 3 pro. I don't know what the last sentence means, but yes. Yaya Tube says you are the best attorney, but hard to find. Yeah. So by design, I work for my clients. I run a firm. I do not make myself available to everybody, right? That's not my job. I do here, right? I do through this process and I try to give back and we have a nice back and forth, but I can't do like one-on-one free help. It's just not, it's not viable. And the reality is it's just a bandwidth issue. Like if there's 30 people seeking that per day, I can't do it. Right. All right, everybody, stream coming to an end. I'm going to take a break. Oh, this is a good one. Prince02 Dunn says, what is the purpose of an attorney asking for a retainer? Depends on what you're asking the person to do. So Prince02 Dunn, a lot of attorneys ask for an upfront retainer because they want the client to be invested in the case. Sometimes attorneys ask for a retainer because they want a truth check under the idea that clients would not invest in a lie. Sometimes attorneys ask for a retainer instead of a contingency. They want to charge hourly because they think the case has too much risk. Sometimes they ask for an upfront retainer because there's a ton of expenses on a case and they want the client to defray some of that cost. Yeah, I mean, it can be just certain markets. Attorneys tend to ask for upfront retainers. Others don't. There's 1 or 2 firms in New York that I know of that still do pure contingency work, but generally in New York, most of the firms I'm aware of are charging an upfront retainer plus a contingency. So, different firms have different reasons or different situations. There's also situations where like somebody calls you up, they got a strong case, but they're pretty upfront. Like all I really want is a job back. Cool. You know what I can't take a percentage of? The job. So we charge something, right? Because you don't want to do a ton of work, a couple hundred attorney hours, and then the person just takes the job and you're like, cool, I'm really glad I helped you. But I paid people a ton of money to work those couple hundred attorney hours, and now we get $0 because you took a settlement of returning to work, and our job is to do what you want. So of course we have to broker that deal for you, but it's not ideal if you didn't charge something. All right, everyone, wonderful speaking with you. I hope you have a wonderful weekend. Take care. I'm going to take a short break. Take care.